As calls for former President Goodluck Jonathan to run in 2027 grows, there have been questions raised by certain individuals about his eligibility. The Federal High Court sitting in Abuja was on Monday was asked to issue an order of perpetual injunction restraining former President Goodluck Jonathan from presenting himself to any political party in the country for the purpose of contesting the 2027 presidential election. The court was equally urged to bar the Independent National Electoral Commission (INEC) from accepting from any political party Jonathan's name or publishing the same as a duly nominated candidate for the presidential contest. The plaintiff, Mr. John Mary Chukwukasi Jideobi, a lawyer, argues that Jonathan has already served the maximum 2 terms allowed under the Constitution, having completed the term of the late President Umaru Musa Yar'Adua and then serving a full term after the 2011 election. Joining us on the show to lend his voice to the ongoing conversation around the eligibility of former President Jonathan is Oba Maduabuchi, a senior advocate of Nigeria. Good morning, sir, and you're most welcome to the morning show.
Good morning, my dear, and good morning, Nigerians. Good morning.
Mr. Maduabuchi SAN, the subject speaks for itself. At issue is Section 137, Sub 3 of the 1999 Constitution as amended, which says that a man who has taken oath of office twice to an elected office cannot be president of Nigeria again. And it's on the basis of that that Jideobi Esquire has gone to court to say, President, you can't hear me? Hello, can you hear me?
Yes, I can hear you.
Oh, okay. Yeah, it's on the basis of that that Jideobi Esquire has gone to court to now say that President Tinubu cannot, President Jonathan, having been president, having taken oath of office twice, cannot run again. However, there's a basic point of law, a trite point of law, which says that a law cannot have retroactive effect. That Section 137 sub 3 was amended in 2018. How does it have effect should President Goodluck Jonathan decide to run in 2027? Please, can you enlighten us on this basic point of law?
Well, thank you, Dr. Abati. Let me start by saying that suit in the Federal High Court of Abuja is an abuse of court process. An abuse of court process is when you want to relitigate a case or an issue that has already been settled by a court of competent jurisdiction. That the issue of the qualification or non-qualification of Dr. Jonathan has been settled by Yenagoa, by the courts in Yenagoa. Nobody has taken that issue on appeal. And until that judgment is set aside, it remains what the law is. And anybody who decides that he wants to take it to a court of coordinate jurisdiction is simply abusing the process of the court. And it's a busybody. That is my first reaction to it. But what controls a given situation is the position of the law when the act in issue was done. What was the position of the law in 2011, 2010, when Dr. Goodluck Jonathan took the oath of office as president of Nigeria? What was the position of the law? Was Section 1373 part of our laws then? You've already said so, that the law came into effect in 2018. So when Goodluck Jonathan was taking the oath of office to complete the tenure of Yar'Adua, there was no statutory limitations in existence then which could inhibit him from running his constitutionally guaranteed 2 terms. There was no inhibition. So when in 2018 you brought in the amendment of 1373, did Goodluck Jonathan take an oath as president after the amendment. If you remember, when Buhari was president in 1983, he killed Bartholomew Owo and 2 others. The biggest backlash he had was that when they smuggled the cocaine, the law, death penalty was not the law in Nigeria then. Why punish them? Go and give them a punishment that was not in existence when they committed the offense. So it is not possible for you now to punish Goodluck Ebele Jonathan for a position that was not in existence when he voluntarily swore to oath as President of Nigeria to complete the tenure of Umar Musa Yar'Adua. It looks like until a few years ago, I think 1 or 2 years ago, judges in the High Courts retired at 65. Is that about 2 years now? Now suddenly it was increased to 70 years. Will those who had retired a month before the coming into effect of that law, that amendment, come back and say, we retired under the old law, but the new law allows us to serve another 5 years, so take me back? Is it possible?
All right.
Hello?
All right. Yes, sir. I mean, we're listening to you. So when we look at this, I hear you, and the matter is in court. It has gone to the Federal High Court in Abuja, so I'm sure that it would be an opportunity to test the law, and as a number of people have already given their own...
Yeah, the audio is low, please.
Can you hear me, sir?
But even though it's low, but I can manage to hear it.
Okay, all right, brilliant. Now, we're looking at a political matter. Is there a loophole, perhaps, or any gaps that ought to be, that lawyers like Mr. Chukwukasi can take advantage of when it comes to this particular amendment? Because you have explained it, and I think it's quite clear to us, but there are also areas around, at least until he goes to court, he'll be able to test whether or not, what you have asserted is correct or by law is received. Did you hear me, sir?
Yes. Now, you see, the position is a very, very simple thing. One thing about law is certainty. The certainty of the present situation is that in 2011 and 2010, when Goodluck Jonathan swore the oath, provision of 1372 was not in existence. It was not binding on him. It was not an option he took. If it was in existence, if he knew that something like that existed, he would have said, no, I want to remain vice president so that I can contest 2 times. But it was not in existence. So I don't know what kind of pyrotechnic anybody will throw up in court that will make a law that was not in existence to suddenly become existent. Unless, of course, it's Jesus Christ who turned water into wine.
And my very dear senior advocate of Nigeria, in Nigeria, they used to turn water into wine a lot. This is the same country that snake swallow money. So anything can happen. Don't be deceived. This is Nigeria. But I want to cite...
there are many things that cannot happen. What cannot happen is that today...
You don't know Nigeria.
I am coming now. Wait now. Today can never be Monday. Today will never be Monday.
Just ask some people, they will tell you today is Monday in Nigeria. Let's not go there. Is it the same country where you see forgery happening? Where you see forgery happening and they tell you that look away from it? Is it in the same country? Let's not go there. Please. A federal high court.
Well, insofar as we know.
No, wait, sir. A federal high court sitting in Yenagoa, Bayelsa State, ruled that former President Goodluck Jonathan was eligible to contest in 2023 presidential election. The presiding judge, Ahmad Dashen, gave the judgment on Friday, marked in a suit FHC YNG CS 86 2022. He also held that Jonathan's right to vie for office of president cannot be stopped by any retroactive law. The suit was filed by Andy Solomon, Ebide Abraham as first and second descendants, and listed Jonathan All Progressive Congress, the Independent National Electoral Commission, as first and second and third defendant, respectively. This is from the 27th of May, 2022. So, why are we even talking about the case if a federal high court in 2022
I don't understand.
has ruled over the case?
I don't understand.
That's my submission.
And remember that there is Njoku's... excuse me. There is Njoku's case in the Court of Appeal, which affirmed that the man had the right to run. And that you cannot treat him with respect to any law made after he had sworn. Yes.
Mr. Maduabuchi SAN, I don't think we should waste time over the false exactions of bathroom and ambulance lawyers pursuing an issue that does not exist. Can we talk about something more substantial? And I would like to know your opinion about what should be done about the electoral framework going forward, particularly with regard to persons who have raised the point that, look, we still need to fix the electoral framework, that there are omissions in that electoral framework if the objective is to have free and fair elections in 2027. That should be the more substantive issues. Lawyers chasing ambulance can do whatever they want to do. We will rely on the courts to interpret the law as it is.
Thank you, Dr. Abati. I will take it from two perspectives. One, the political perspective, and two, from the legal perspective. You see, we don't run away from our shadow. Our culture here, political culture here, is after elections we go to court. We have developed that culture, and I don't see us leaving it for some foreseeable future. But now in court, it is the plaintiff, the petitioner, who has the onus of proving that an election was not properly conducted. And this is an election he never conducted. It is like asking somebody outside to tell me how I slept in my bedroom last night. So the first thing to do is to amend the Electoral Act so that certain aspects of the Evidence Act will not apply to election petitions. It is INEC that will come and explain how it conducted the elections. When I have said, these are my observations, he will come and say, no, these are the proper things. The onus should be on INEC to prove that they observed their laws, observed the Electoral Act, and observed all necessary procedures. Insofar as you throw it to a petitioner who is an outsider, who doesn't have the facts, INEC might decide not to give you any documents. And what do? After 14 days, if you don't file a petition within 21 days, it will lapse. If you apply for any document, they have 14 days to dilly-dally. After that 14 days, you have only 7 days. If it is the presidential election that covers the whole nation, what can you do in 7 days? But if the onus is on INEC to show that they conducted an election properly, I think it will make them sit up. Secondly, if it is found that in a given polling unit or polling station that there were irregularities, the polling officer there ought to be punished. Because I don't see how 10 people will vote and you return 35 votes. Or they issue 10 ballot papers and you have 13 votes, when each ballot is supposed to be a vote. So the man who made that recording ought to be made to face the music. But in Nigeria here, nothing. Once they come, you go, give money to the man at the polling unit, and they say, how many electoral registered voters we have? 300. How many people voted? 20. Okay, so there's 100. Yes, okay. That 100, give 80 to the other party. And that's all. The man wins. The person they gave 80 wins. And the man who really won loses. If eventually it is found out that this is what happened, the person that did it walks home with the money in his pocket. So there are certain things. Politically, we have to change how the chairman of INEC is appointed. I do not see how we cannot have the Supreme Court justices, retired Supreme Court justices. They are not saints, but by now they don't have any interest to serve. So if they are the people who are to appoint and send to the Senate, insulating the president, who is obviously interested, if you remove the president from it, because that is where the problem starts. But somebody will tell me that Jonathan retained Jega and still he lost. That is a possibility. But we cannot use one. I remember there was an INEC chairman who always said, go to court. Go to court. We are in a given state in the southeast. They say we were asked to return PDP. After that, they will send us names. What kind of INEC is that? We were asked to return PDP. Where somebody will get up and say, I gave all the names, Holy Moses.
All right, sir. I'm glad you talk about the appointment of the INEC chair, but also we should also look at other principal actors, like the state recs, for instance, the resident electoral commissioners in the states. And these are professors, yet we still have challenges in the states. So when you talk about bringing on board retired Supreme Court justices, would that be the solution? Because we have, as long as they're Nigerian, they have access. We have professors, and we see some of the things that they do even play out, publicly with regards to how they conduct or oversee the elections in their states. How can we really deal with corruption at this level as long as money is a factor and we can have people who are willing to compromise? Would appointing, for instance, your suggestion, retired Supreme Court justices or judges, would that be the solution to getting it right when it comes to leadership in INEC?
You see, what I said is simply a suggestion. I was just thinking out loud. That was not why I came here. So maybe I didn't give it really deep thoughts. But it is an alternative. It is something that we can begin to consider. But saying that the president appoints somebody that will, I want to get a PhD and I appoint Dr. Abati to come and supervise me, how will he fail me? It will be difficult. Just like you said, Nigeria is a country where corruption is our breath. I don't know how we are not going to import people from Mars to come and run the country. Nigeria is a place where it doesn't matter how you made money. The important thing is that you came home with money. If you work and retire from civil service and you don't have houses, cars, and you don't live a flamboyant life, in Igbo language you say, he didn't come back with anything. And you see people who are flaunting the level of riches that is so gargantuan that you begin to wonder, when did this people start? Suddenly you begin to hear people's names. So then the way they throw money around as if it's confetti. So the moment, so far as we allow corruption to control our lives, we will be subject to that, but it will not stop us from making suggestions which will be considered by the National Assembly. And if it suits their fancy, because that's another totally different kettle of fish. If you hear what happens in the National Assembly, because now we don't have legislators, they're all contractors, running from pillar to post to do constituency projects, collecting contracts from ministries they supervise, and so on and so forth. So we cannot be despondent. We cannot lose hope. We must continue and strive to see how we can throw up alternatives, hoping and praying that one day we'll have another Jega. It was only under Jega that Nigerians became united. That this is a man, that is a gentleman.
Okay.
So it is not really. Sorry. Sir.
Okay. No, I was just going to say.
It's not really the system.
Go ahead, sir.
Yes.
Go ahead, sir.
It is not really. The system may be bad, but I think what is really worse is the person. The person that hurts it. Like the question I was asked, the usual thing is that a rec is in a state, once they post him, the chief of staff visits him, and do you have, I hope you have a house. Yeah, well, they haven't got me one, don't worry. They're giving 25 million naira, go and get a house. Okay. This is the man you've come to supervise his.
Okay.
So the thing, and then finally, Abati, when they want to employ ad hoc staff, it is the government that sends the names of those who will man the various polling units to INEC.
Okay, just to return to
each watch chairman.
Just to return to where we started from, about the eligibility of President Jonathan or not, or otherwise, in 2027. It's also an issue about fair hearing. Section 36 sub 8, as you will affirm, makes it clear that a man cannot be punished for a piece of law that did not exist at the time he committed an offense, just using a generic word. So you can't say President Jonathan will have to be punished or denied his fundamental rights under the Constitution when that law did not exist.
Okay.
Anyway, thank you very much.
That was the first thing I. That was the first thing I said. That was the first thing I said.
Yeah, no,
that it is the position of the law.
No, I'm just confirming what you said.
It is the position of the law. Yes.
I'm just confirming what you said. So we would like to thank you very much for joining us on the morning show. Thank you very much indeed.